So this is all about the living will declaration concerning life-sustaining procedures. I'm Paul Rabelais. I'm an estate planning attorney. You can find out a lot more information about estate planning by checking out our podcast, Estate Planning with Paul Rabelais, YouTube channel, Rabelais Estate Planning LLC, or website, RabelaisEstatePlanning.com. Constantly putting out content. Really my strong desire, what keeps me here in the office late at night, sometimes on the weekends like it is now, it's Sunday, is I want to really make sure that the public is up to speed on these issues so they can make informed decisions. So to the extent you can provide guidance and feedback through comments or otherwise, feel free to do so. Other people will see it and benefit from it. So today it's all about the living will. Some people get it, some people don't really understand it. Nobody, I'm sure, has read the intricacies of our Louisiana living will law. So I'll start with the basics. We'll move right through it. We'll go through it kind of quick. Everybody, every person, every adult has the fundamental right to make their own medical decisions and to control their medical care decisions, including the right to authorize the withdrawal of life-sustaining procedures in the event of a terminal and irreversible condition. So how all that gets done, it gets done through something that's called a living will. It's typically a document. Maybe it's one page, maybe it's two. We're going to go through some specific provisions in a minute. It's got to be witnessed by two people. And again, that needs to be two, non-family member witnesses, not related by blood or marriage. They don't want people who will benefit financially from your death to be signing as a witness on your living will. And so there's a procedure for somebody making an oral or even a nonverbal living will after they've been diagnosed as having a terminal and irreversible condition. But most of the living wills, vast majority, probably 99+%, are all the kind of traditional, standard, written living will witnessed by two people. Again, just note that a notary isn't required to get a living will done, whereas a notary is required on virtually all of the other estate planning documents, whether that's wills or trusts or powers of attorney. So, but I guess they want to make it a little easier for people to state their wishes regarding life support. Okay, what I'm going to do is I'm going to jump right into the default or sample living will that our legislature created. I'm not going to read the whole thing, but I'm going to go through one paragraph. It should give you an idea of what most living wills provide and what you'll be, if you sign a living will one day, what you'll be declaring. So here's the critical paragraph. It says, if at any time I should have an incurable injury, disease, or illness, or be in a continual profound comatose state with no reasonable chance of recovery, certified to be a terminal and irreversible condition by two physicians who have personally examined me, one of whom shall be my attending physician, and the physicians have determined that my death will occur whether or not life-sustaining procedures are utilized, and where the application of life-sustaining procedure would serve only to prolong artificially the dying process, I direct. And then you have to make a choice by initialing one of the two following statements. So if all those things apply, then you direct that either all life-sustaining procedures, including nutrition and hydration, be withheld or withdrawn so that food and water will not be administered invasively, or you select the other one, that life-sustaining procedures except nutrition and hydration be withheld or withdrawn so that food and water can be administered invasively. So it goes on one other sentence. I further direct that I be permitted to die naturally with only the administration of medication or the performance of any medical procedure deemed necessary to provide me with comfort care. So what all that means is, when you're out of it, and I'm being blunt and I'm being fast, but when you're in that state, there's no chance of recovery. Machines are just artificially artificially prolonging the dying process. Then you state that, take me off the machines, and then you'll state either keep me on food and water or take me off of food and water also. Okay, and just know that if you want to know more about what some of those things mean, there are definitions in our living will law. There's definitions of a witness, there's definitions of attending physician, there's definitions of terminal and irreversible condition, and there's definitions of life-sustaining procedures. So sure, there are those provisions in the living will. and then they're backed up with all of the law and all of the definitions that are in our living will law. So just know that that exists. Okay, if somebody doesn't have a living will, who gets to make that decision? So there's a pecking order of who can make that decision. If you don't have a living will, who can make the decision to withdraw life support machines? So I'm going to go through 6. The first one is your court-appointed curator, guardian. Most people, when they're in that state, they've never gone through the process of being declared incompetent by a judge, having a judge appoint a legal guardian. But if there's a curator, that's who gets to make the decision first. Second, it's the person that's designated in a written instrument, witnessed by 2 people. So you can sign a statement that says, I want this person, or if not this person, that person, to be able to have the decision-making authority to withdraw life support machines. So that's second after the curator. Third is your spouse. Fourth is your adult child. Fifth is your parents. Sixth is your sibling. And if there's more than 1 people in that class, then after there's been a good faith effort to notify all of the children, for example, then a majority of those can make that decision. So what it comes down to is I'll say 3 scenarios. Scenario 1, guy comes in, says, I don't want life support, too much money, don't want my family to suffer, don't want them to make that decision. Where do I sign my living will? So that's one set. Second set is, I don't want life support. I don't want to put my family through that. I want to make my wishes known that I don't want to be on life support. But I trust my family more than I trust the doctors or the hospitals. So let me sign a statement stating what I want, but allowing my spouse, child, whoever, to have the final decision-making authority. So the first one was you keep your family out of it. You don't want to burden them with the decision. The second one is you want to state your wishes, but allow your family to make the decision because you feel like they'll take the emotion out of it, and they know better than anyone else what you'd want, and who knows what kind of condition you might be in the future. And then the third is I don't want a living will. I don't want to state my wishes. I want my family to be able to make all those decisions. They know what I want. I'm not going to sign a living will, and just let my family make that decision. None of those 3 are either automatically right or wrong. The key is to get educated so that you're making the right decisions. So hope all that helps, and you have a good afternoon. Take care of this stuff ahead of time. We'll see you.